The Fair Debt Collection Practices Act was passed to deter abusive debt collection practices. The act is a strict liability statute, meaning collectors who violate the act can't avoid liability based on their mistaken beliefs. However, in McCollough v. Johnson, the Ninth Circuit explored the act's bona fide error defense. In 1990, Tim McCollough opened a credit card with a predecessor of Chase Manhattan Bank. After McCollough fell behind on payments in 1999, Chase sold the account to CACV of Colorado, a debt collection agency and subsidiary of Collect America. In 2005, CACV sued McCollough but dismissed the case after McCollough asserted that the statute of limitations had expired. A year later, Collect America hired Johnson, Rodenburg, and Lauinger to attempt collection. In the contract, Collect America disclaimed any warranties regarding the accuracy of its data and made Johnson responsible for determining whether to attempt collection. In 2007, Johnson noticed that the statute of limitations on McCollough's claim expired in 2005 and asked CACV for information that could be used to extend the limitations period. CACV incorrectly told Johnson that McCollough made a partial payment in 2004. Johnson filed a complaint against McCollough in state court. McCollough filed an answer asserting the statute of limitations and told Johnson that he hadn't made a payment since 1999. CACV also told Johnson that it had been mistaken and that McCollough hadn't made a partial payment in 2004. Nevertheless, Johnson sent a request to McCollough for numerous admissions, including an admission that McCollough made a partial payment, that McCollough never disputed the debt, and that Johnson's complaint was accurate. In response, McCollough retained counsel, and CACV instructed Johnson to dismiss the suit, which it did. McCollough filed a claim against Johnson for multiple violations of the Fair Debt Collection Practices Act and other related state laws. A jury found in favor of McCollough, and the district court granted summary judgment against Johnson on the fair debt claims. Johnson appealed to the Ninth Circuit.